Good evening, everyone, and welcome to the Marion Minor Cook Athenaeum. My name is Maya Ghosh, and I am one of your Ath Fellows for the rapidly closing year. Yeah. The 2021-2022 Supreme Court term has been nothing short of monumental. The decisions of the 9 justices will influence the American social, economic, and political trajectory for generations. In a conversation moderated by CMC President Hiram Chodosh, Eugene Volokh and Kimberly West-Faulcon will discuss predictions and insights from 4 landmark cases. Dobbs v. Jackson Women's Health Organization on abortion and reproductive rights, New York State Rifle and Pistol Association Incorporated versus Bruen regarding the Second Amendment, Carson v. Makin on freedom of religion, and Students for Fair Admissions Incorporated v. Presidents and Fellows of Harvard College on the controversial issue of race in college admissions. Kimberly West-Faulcon is a professor of law and holds the James P. Bradley Chair Professorship in Constitutional Law at Loyola Law School, where she teaches topics such as originalism, the Second Amendment, equal protection, abortion regulations, and LGBTQIA rights. She is a scholar of constitutional and anti-discrimination law, as well as a pioneer in the interdisciplinary research of law and standardized testing. Eugene Volokh is a professor of law at UCLA Law School, where he teaches First Amendment law and a First Amendment amicus brief clinic. He has often taught criminal law, copyright law, tort law, and a seminar on firearms regulation policy. In addition to his academic work, he has also filed briefs in about 75 appellate cases throughout the country, has argued in over 20 federal and state appellate cases, and has filed briefs in the U.S. Supreme Court. Tonight's discussion is co-sponsored by the Open Academy at CMC. Now, before we begin, just a few reminders. Remember to keep your mask over your nose and mouth for the duration of the program indoors. Take a moment to also silence and put away your cell phones. Take a deep breath. Remember to be present in the moment. Take out a piece of paper and a pen, jot down some notes because we will have some time for Q&A at the end. Now, without further ado, please join me in welcoming Professor West-Faulcon and Professor Volokh to the Athenaeum.
Thank you, Maya. Your introduction is so outstanding. I think my job is done for the night. I want to thank Priya for pulling us together with this salon, Supreme Court Matters. We've been doing this kind of program for the last several years, and it's wonderful to be a part of it. Normally, George Thomas does the moderation, and he does a superior job. He had a conflict tonight, so Priya pulled me off the bench or out of retirement to see if I could ask a couple of questions of these outstanding scholars. Eugene, many of you may have seen here before. I think his 3rd appearance at Supreme Court Matters. And Kimberly, it's great to have you. It turns out that Kimberly took the exact same formula of professors in her first semester of law school as I did. So we've been sharing stories about our favorite mentors and maybe get into a little bit of the things that we learned from great scholars like Eugene and Kimberly tonight. Well, we have a big agenda tonight. I mean, we could spend a few hours on any one of these cases, so it's going to be a little challenging for us to work through it, to give all of you enough foundation in the area, and to see if we can reach some more profound and insightful comments than you would typically find in the news or some of the public media. Well, we say the Supreme Court matters, but why does it matter? What role does it play in our society? We take a snapshot of these particular cases. There'll be an outcome. You'll hear from Eugene and Kimberly a little bit about what their predictions are. I think they're pretty nervous about that because it's very hard to predict what's actually going to come out of the Supreme Court. But one of the lessons I think we ought to keep in mind is it's a snapshot in a long motion picture. It has a deep history, but it also has an indeterminate future. There's a lot of response and reaction, legal and non-legal, to every decision that comes down from the Supreme Court. So no matter how disappointed you are or concerned, you can always rechannel that energy into what is the constructive response as we go forward in our legal process. All right, so we're going to dive in, and I'm going to turn to Kimberly first to introduce us to this very, very important case on reproductive rights in Dobbs. So lay it out for us.
So I'm happy to do that. And did you want me to give a little take
Yeah,
on
a
why
little, like,
the Supreme Court matters? I mean, I love that's
what's-
such a provocative idea.
What's at stake here? What is this case about? What are the primary precedents that the Supreme Court is grappling with? What do you think is going to happen? And then, based on that prediction, what do you think will happen after that? Because it is not the end of this story.
Right. Well, I will, because I do by trade and maybe obsession, talk about the Supreme Court writ large and why it matters. I do want to take a moment and then I'll dive into Dobbs. Why the court matters, big picture, is that we've all entered into a social contract with one another. We don't want to live in a society where we have absolute freedom, as nice as that might seem, because that would be a version of living in the purge, where everyone could do whatever they wanted. So in exchange for a civil society, we've agreed to be regulated by majority rule, but with exception. And that's where the Supreme Court fits in. Because when you're in the majority, you love majority rule, and when you're not in the majority, it is an abdication of all the principles of freedom and justice, you feel like. So why the Supreme Court is very important and why its integrity is intricately important is we need an arbiter. We need an entity in our our co-equal branches of the federal government that can step in when, heaven forbid, our executive, our president, oversteps his power. That to this point, it's only been his power, or when the Congress exceeds and steps out of bounds of its power. The court is our protector in that system, our protector from our local and state government oppressing us. So big picture, the Supreme Court matters because without the Supreme Court, we can't protect our liberty and our freedoms, no matter what we believe they are. So to go to this case that a number of us are watching, Dobbs, a case about where the issue is, and I always like to bring up and describe the issue in terms of what government power, what government action is at stake. And so the issue in this case is the action of the Mississippi government to decide for an individual who is pregnant whether or not they can legally terminate a pregnancy. And I like to use the term pregnant person in the last several years, not because, as it's become part of some questioning, I don't understand that all the people who are pregnant are women, but because in the class where I've taught this, I really felt that even the term, sadly, women, was flattening out how this is a question about government versus a person's body and their bodily integrity writ large. Not that that's necessarily how the court has always described it, but the issue is whether the Mississippi government can decide whether it is illegal for a pregnant person to terminate a pregnancy before it is possible to have life outside of that pregnant person's body. That's what the issue is. And as a matter of the legal precedent underlying this question, it's not what you usually expect in a case. You usually expect in a case for there not to be a settled precedent on point. But the settled precedent, both sides in this case actually agree that the court's decision in Roe v. Wade, which is from the 1970s, and a subsequent case, Planned Parenthood versus Casey from 1992, that both of those cases establish that the word liberty in the Due Process Clause of the 14th Amendment protects an unenumerated, aside from referencing liberty generally. So there's nothing in that clause that says specifically you have control of when you would terminate a pregnancy. But those cases, as a matter of precedent, stand for the doctrinal rule that a pregnant person does have a fundamental right to terminate a pregnancy before life is possible outside that person's body, otherwise known as viability. I think it's also important to know that since the 1970s, the government has had the power to ban abortions completely after life is possible outside of the person's body, so long as there are exceptions made for the health and life of the pregnant person. What changed in Casey, Planned Parenthood versus Casey, which is pretty similar to where we are now, Republican presidents promised to appoint justices to the court that would overrule Roe v. Wade. We saw the court in that case, Casey, do something that, for many people, enhanced the court's integrity, because those justices did not overturn Roe v. Wade. Instead, many of them articulated that because of the principle of stare decisis and a commitment to precedent, that even though they individually would have decided Roe v. Wade differently had they been on the court in 1970, that using the precedent on when you overturn precedent, they were going to uphold the part of Roe that says there's a fundamental right to terminate a pregnancy pre-viability. However, they did make a big change in the doctrinal rule, which is that in general, when we talk about acts of government power, what the court does is it applies different levels of scrutiny. And I tell my students one is a rational basis standard that's like walking over a speed bump. And it's very easy for the government to get over the speed bump. There's intermediate scrutiny and strict scrutiny if you're looking at equal protection analysis. So strict scrutiny is like hurdling, it's like a pole vault. I can't pole vault. And hurdling, also very difficult for me. I'm not that athletic. But rational basis review, I could walk over a speed bump. So what the court did between Roe v. Wade and Planned Parenthood versus Casey is it lowered the standard of review from strict scrutiny to not intermediate scrutiny, but its very own test, the undue burden test, which is really like a hurdle that moves up and down depending upon the judge who is applying it. So it's not ideal. So what we have in Dobbs is we have acts of government that were purposely designed to violate the legal rules in Planned Parenthood versus Casey, so that you have the legislators knowing that these laws were unconstitutional. But because they want to get to the Supreme Court to have the actual precedent reevaluated, revisited, and possibly overturned, they have purposely designed a government action that is in violation of Casey. So no one is going to the court saying, we think this is consistent with Casey, but it is because there are new justices on the court that have a different view of what the word liberty in the Due Process Clause means. They believe it does not and should not protect rights that are not literally listed out as the rights in the Bill of Rights, such as the right to bear arms is, that is the theoretical debate amongst these justices that will be ultimately probably decided. And so depending upon whether we have enough justices willing to overturn prior precedent and have a view that the word liberty in the Due Process Clause, I'll use Justice Thomas as an example, he has a very narrow definition of liberty. He believes it only protects physical liberty. It only protects the government from literally locking you up. If that is the narrow view of liberty you have when you interpret the word liberty in the Due Process Clause, you would be, as Justice Thomas is inclined to do and has been very clear he wants to do, overturn both Roe v. Wade and Planned Parenthood versus Casey. So that's what we're looking to see. And so the implications are that with that narrowed view of the term liberty, substantive due process analysis in other areas of law could also be at issue.
Kimberly, you said that this liberty interest was an unenumerated one, and we talked a little bit about how the issue's framed. So describe for us the effect of the framing itself. And particularly if you go back to Roe, looking back, are there certain infirmities in the way Roe was adjudicated that you feel created vulnerability in that precedent? So, for example, the inference of a right of privacy, which is a little bit different than the notion of bodily integrity. So tell us a little bit about your views on the importance of the framing of the liberty interest and how foundational, the strength of the foundation on which it sits and whether it can sustain challenges later.
I frankly, as someone who teaches these cases every semester in my classes, am not inclined to think that, one, the privacy articulation is very much in Griswold versus Connecticut. And I teach my students that you don't go to court and talk about penumbras and emanations and the lead case in Griswold versus Connecticut. Even in the concurring opinion by Justice Harlan in Griswold, the substantive due process analysis was there. And so the doctrine, and this is what I'd say if you're taking my final exam in constitutional law, the doctrine's pretty clear about what substantive due process is. And so I do not think it really matters anymore unless you're, and I will steal a Justice Scalia joke, unless you're trying to get tenure tenure on a law faculty, that's really not what the conversation in the court is about, because everybody knows what the doctrine is. What really makes this moment different is we have justices on the court who have very different views about what stare decisis means. And there has long been a big difference between now deceased Justice Scalia's views about stare decisis, where he would sarcastically deride an opinion and precedent with which he disagreed, but would give it deference. And Justice Thomas, who is not just an original meaning originalist, they share that. But Justice Thomas has long said that he does not really believe in stare decisis, that if he, as a matter of theory, believes a case was wrongly decided, he will overturn it. And the consequences are not, he's not concerned about those consequences.
What's the settled constitutional threshold for, because there's doctrine on stare decisis itself,
so
that the court has to grapple with in this particular instance?
So the doctrine, and one of the places where it's articulated, is in Planned Parenthood versus Casey itself. And it is that first the court will consider whether the legal rule, so undue burden test, and that's kind of part of one of the arguments that you might see, whether the legal rule is unworkable. Now, none of these are going to be bright line rules. The justices have immense discretion in applying even their own standards about stare decisis. The second will be whether or not society has relied on the prior doctrinal rule. And so a lot of people think that is pretty clear, that people have relied on having this fundamental right to terminate a pregnancy pre-viability protected, whether there's been a change in law or a change in facts. But what has also changed in the last few years, and in a case Janus, current justices of the court, have also been changing the precedent on when they have to and when they can deviate from precedent. And so now justices on the court are saying whether the opinion that they are considering was reasoned properly. And so that is starting to give them a lot more deference. And so I think what we have is a set of justices who are in the 6-justice majority who are not just original meaning originalists, they're quite activist, that they have a very judge-empowering approach to the Constitution. And what that means is if there is precedent with which they disagree, they're creating precedent that makes it more possible for them to change the doctrine. And so I think we've always had justices who believed that doctrine was inaccurate and wanted to change it. What we're waiting to see, and why we are so wrapped in what's going to happen in June, is while we understand the theories of constitutional interpretation these justices have, we don't between Justice Barrett and Justice Kavanaugh. We know Justice Thomas. Justice Thomas has written many a concurring opinion saying, if you let me get to this precedent, I will be done with it. And I tell my students their very thick constitutional law case book could be very different in the future if there are 4 more Justice Thomases. It wasn't as clear what would happen if there had been 4 more Justices Scalia. And so that's not the sort of thing that people might expect me to be saying, but that amount of room between a Justice Thomas view of stare decisis and a Justice Scalia view of stare decisis could make a big difference in cases like this.
And we have some justices who are rather untested in this result. So give us your best prediction. What do you think is going to happen?
We already told you, both of us, that neither of us are big on predicting.
I'm going to force a prediction.
So I would say that who we're watching, who we're unclear about, is Justices Barrett and Kavanaugh. I will definitely feel confident predicting that Justice Thomas, Justice Alito, and probably Justice Gorsuch will write opinions somewhere along the way that say they're willing to overturn Roe v. Wade and Planned Parenthood versus Casey. I would say that Justice Roberts would probably want to have a narrower conclusion, and maybe Justice Kavanaugh, and I just don't know about Justice Barrett.
I hope we can get into this a little later as to what is the nature of the court, the Roberts court, going to be. Eugene, I know this isn't your exact area, but obviously you study this a lot. What are your views on the significance of this case and what's about to come?
Well, it's certainly going to be very significant as a practical matter. You know, there's some cases, flag burning, for example, something very interested in. I think the court got it right in upholding the right to burn a flag. Not many people's lives are affected by flag burning. A lot of people's lives are going to be affected by if the court allows states to ban abortion. And by the way, pro-life people will say yes. A lot of people's lives will be saved. Unborn people's lives will be saved by it. My sense is it's a lot less now than it would have been at the time of Casey for two related reasons. One is that pharmaceutical abortions are much more common and will become still more common. And while there will be limitations that states try to impose on that, that's just very hard to do. Look, if you can't ban cocaine, you're going to have a very hard time banning abortion pills, which are freely available in neighboring states. Also, transportation has gotten somewhat easier in many ways. And while there's no doubt that, especially for poor women, having to go, especially in a big state like Texas, having to drive to, I don't know, Colorado or something, it'd be really quite burdensome, but it's certainly easier than it was, say, at the time of Roe, probably even easier in some measure than the time of Casey. But it is going to be practically really important. I do want to touch on one thing I want to, that's a little bit more meta, and I'm very glad we got to this question of precedent. And one thing that particularly struck me is the question of whether say, conservative justices are particularly activist and judge empowering, because it shows how complicated those terms are. So let's say that they decide to overrule Roe and Casey. That is activist in one sense, in that it's active. They are affirmatively changing the law. It is also judge empowering in that they are saying, we are going to make this decision, we as judges, rather than saying our hands are tied by precedent, our hands are untied and we can do all sorts of things with our hands. On the other hand, let's say somebody votes to reaffirm Casey. Well, is that judge empowering? Well, it certainly empowers those justices who in Casey, and even more so in Roe, made the decision to strike down the state statutes, right? Roe was certainly a judge empowering decision because it shifted a question from the political process, perhaps quite rightly, but shifted it from the political process to the judicial process and had judges make this decision. And I take it you could say that if justices say, well, we're just adhering to Roe, they could still be continuing this judge empowering process where in the country, abortion, unlike some things, but unlike other things, is decided on by judges more than by legislatures. Likewise, is it activist? Well, in a sense more passive, you might say, to reaffirm precedent. But on the other hand, that precedent means state law after state law gets struck down. So you might say that reaffirming this precedent is activist. Now you might say certain things might have been both activist and judge empowering under any definition. So Roe v. Wade, again, perhaps quite rightly, probably was both. Because it was something where judges pretty much for the first time in American history took this abortion question and took it out of the political process into the judicial process. It was just a decision of those 7 of the 9 justices. But for a question like this, and for lots of other cases as well, activist is not a well-defined term because it could mean different things. Judge empowering is not a well-defined term. So just a warning, when you hear people talk about activism and judge empowering, those are important concepts, and I certainly understand why they came up, but they could come out, they could play out in very different ways.
I'd love to, if you don't mind,
Please.
engage, because while we are, like I say, no degrees of separation separated, we have not had this kind of conversation. So I, one, as someone who has read the law review article you've written that's cited in DC versus Heller, I have no idea whether you engage with originalism as a theory of constitutional interpretation, or
I am not an originalist.
Okay, that's
I'm not an anti-originalist, but I'm not an originalist.
That's always what I've wanted to know. I told my students in my class, advanced topics in constitutional law originalism, that I would leave tonight knowing whether Professor Volokh was a self-described originalist. So now I know that answer. So whether you were or you weren't, I was still going to say what I'm about to say, which is that I am very carefully selecting the term judge empowering. And thank you for giving me the opportunity to have the conversation with you to say that I don't use any of those terms very lightly. And I think it is absolutely right that with an audience like this, we don't use them lightly and we engage with defining them. I also am very careful not to use the term conservative to describe the current court, because if I think you are activist, I am using that in not as your ideology, but as my assertion of whether you are one that is going to keep the status quo or change settled precedent. But my judge-empowering observation is more a description of what I am concluding about original meaning originalism. Not specific intent originalism, which is the kind of originalism you think that you're going to hear about, which is I care exactly what James Madison thought if I could get in a time machine and go in the room and say, hey, James Madison, what does the Second Amendment mean? That I would be bound by what James Madison told me. I think that would be fairly restrictive if every justice on the current court saw themselves as a specific intent originalist. I would not say that is judge empowering. It certainly would require some capacity to figure out what James Madison thought, but it would not be as judge empowering as what my observation of original meaning originalism is, as well as many of these justices' preferred approach to statutory interpretation, all of which sound very constraining, and I'm regularly crediting these justices with having names for what they do that sound very constraining. But it is my observation that, one, when you have a theory of constitutional interpretation that you deem so superior to everyone else's that you will say, if precedent is wrong, I will overturn it, that's what I think, one, makes you more willing to change the law and therefore more activist, but that what we're now hearing from this court, and we're getting ready to talk about New York Pistol Rifle Association soon, but a court that is much more concerned in what their individual capacity to assess historical documents and the history surrounding particular provisions of the Constitution than precedent. And so now when I listen to oral arguments, I hear what to me sounds like a very judge-empowering process going on. I don't hear judges asking attorneys before them, what did these prior cases tell us this provision means? What is the doctrine? How do we follow or distinguish it? I instead hear a court that is more often than not willing to go back to the original provision and say, we, in 2022, are about to give you its original meaning, and I feel that's very judge-empowering because they're not constrained by either Casey or Roe v. Wade. We'll get a new definition of the word liberty.
This is a great conversation for all of you to hear. We used to say in law school, whatever you can do, I can do meta. And I think it's a great segue to New York.
Right.
So tell us a little bit about this case, and I'm particularly interested in this problem or challenge of a self-defined judicial philosophy, and whether Eugene, in the context of this case, and Heller, whether you think that judges are really self-bound by their own judicial philosophy. Like, should we take them seriously?
Right.
Or do they contradict themselves and then tie themselves up into pretzels because they may not like the outcome of the application of the judicial philosophy that they've announced for themselves?
Right. Well, so that's an interesting general question. I'm not sure that that's going to play out quite as much in New York State Rifle and Pistol Association. But in general, the only thing we know about judges for sure is before they're judges, they are people. Some people might say even before they're people, they are monkeys or primates, technically, right? So we people have a tremendous capacity for not just trying to delude others, but deluding ourselves, right? So it's the most human thing in the world to say, oh yes, I have a set of principles, and somehow they all come out in the way that satisfies my other preferences. So there certainly would be nothing shocking if someone who believed in any particular theory, whether it's precedent or based or whether it's original meaning or whatever else, would end up just how convenient, the original meaning or the precedent or whatever points exactly in the way that it wants. So I'm sure there's some degree of this tendency because judges are people. I also think that there is a great deal of constraint as a practical matter. We often don't even notice it. So, for example, Justice Rehnquist, his general theory, not always, but general theory was kind of deferring to the government. And you could tell he was a conservative politically as well. He actually didn't like a lot of the economic regulations that the government was imposing, but he routinely voted to uphold them because I think he really did think that's all for the political process. He was somebody who actually had a relatively narrow view of free speech as a general matter, and in particular with regard to commercial advertising, which nowadays is actually, it's more a liberal position that commercial advertising should be more restricted, and a conservative position that should be more protected. Back in the early cases, it was Justices Brennan and Blackmun, who, especially Justice Brennan, who pushed the hardest on this, arch-liberal, and Justice Rehnquist, who is the arch-conservative, who was the one who was saying, no, this is not something we should be doing. And I think that was out of, not because he really thought commercial advertising is awful and needs to be suppressed, but because he really did believe in his theory, which was kind of minimal protection of constitutional rights, which is to say they had a core, but it should be kept really, really narrow and leave lots of room for democracy. I'm not sure how this all comes out in New York State Rifle and Pistol Association, so let's just turn to the legal issue there. So the Second Amendment says the right of well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And the Supreme Court had relatively few cases about the Second Amendment throughout its history. Vastly more about the First Amendment, about the Fourth Amendment, about equal protection, about due process. First Amendment, several cases a year. Second Amendment, you put them all together over the last, even let's focus on the last 100 years, because, for example, First Amendment cases really only came to the court in large numbers 100 years ago. I think at this point it's had 5 maybe, and then several that sort of were tangentially connected to it. So one reason, interestingly, why Second Amendment cases have been so originalist is probably because there's much less precedent. There was United States v. Miller from 1939, a weird case and weird context, but if you look at D.C. v. Heller, which in 2008 said, yes, this secures a right of the people in the sense of right of each one of us to at least have a gun at home, both the majority and the dissent were talking the talk of originalism. Now, maybe some of the justices just did that for tactical reasons. Maybe the very fact that they could come up with plausible arguments, originalist arguments both ways, shows that originalism is unconstraining. But they were, it was definitely an originalist decision in many ways, and with an originalist dissent. So now, since then, what has the court told us? It told us a big thing, which is that the right applies to the states. You'd think that's obvious, but the first word of the Bill of Rights is Congress. The Bill of Rights originally, of course, only applied to the federal government. Most of the Bill of Rights has been applied to the states through the 14th Amendment, but there's still always a question for every newly recognized essentially right. And the court said, oh, it covers Chicago in that case, which had a handgun ban, as much as DC, which had a handgun ban. Then there was a case which said the Second Amendment, I oversimplified, but basically ended up saying, protects stun guns. You wouldn't think that's what would be the next case, but that happened to come up to the court. And the court, even without oral argument, reversed the Massachusetts High Court decision, which said, no, stun guns aren't really arms. And the court said, no, your analysis is wrong. Do some more work on it. And eventually the Massachusetts court said, well, okay, fine. We're going to strike down the stun gun ban. And now there is actually another very important question, which is what about the right to carry guns in public? Not in every public place, not, for example, in a public school or an airport, but in your car, on the street, onto private property, at least as long as the private property owner doesn't purport to ban it. So one question is, if keep protects the right to have guns in the home, does bear protect the right to carry them in public? And of course, there is an interesting original meaning question. There's no doubt that bear arms sometimes means fight in an army, fight in a military force. And in fact, I believe, I'm not sure if it's still so in the citizenship oath, but it certainly used to be that you had to promise to bear arms for the United States. But also, bear arms has at times been interpreted as meaning to carry guns, and not necessarily in a military context. So the analysis ends up being much more complicated than just what does arms mean, what does keep mean, what does bear mean. It's what does bear arms mean in this particular context. And it turns out, for example, that throughout the 1800s, a good many courts interpreted mostly state constitutional provisions that had very similar language, and generally, not exclusively, generally said that bear arms means carry guns, and that states can regulate the carry and can ban concealed carry and allow only open carry. By the way, today, I think many of us think, oh my God, open carry is horrible. Concealed carry, well, so long as people keep it out of sight, In the 1800s, the view was concealed carry is what dishonest assassins did, and good people, good, honest folk, carried openly. So in any event, in the 1800s, a lot of state courts said the right to bear arms is the right to carry arms, but of course, if you want, if the legislature wants to say no concealed carry, only open carry, that would be permissible. So one of the things that we're seeing in New York State Rifle and Pistol Association is that in addition to original meaning, there's also the question of how the right had been interpreted nearer to the framing than we are now. Partly because it's seen as kind of shedding some light. What was decided in the 1820s and 1830s is shedding some light to how it was understood a few decades before, but also because justices generally, in all sorts of areas, view tradition as pretty important. Of course, there are often rival traditions. There's been a tradition of regulation as well, but the tradition of recognizing a right to carry is something that state courts had recognized. So that's going to be the shape of the debate. To what extent do you treat bear arms as referring just to the military meaning, in which case it basically means nothing in the Second Amendment, doesn't really add anything to the keep arms side, and to what extent do you view it as carrying guns, and how much weight you put, for example, on the 1800s cases?
This is what I don't understand about the Second Amendment cases. In all rights, there are always doctrinal exceptions.
Right.
To the full.
Surely in
right?
the Second Amendment.
Whether it's free speech, whether it's
Right.
so,
Second Amendment, they're
so,
huge
So what
exceptions.
I mean, this notion that New York cannot say that you have to get a license to prove that you're getting this gun in self-defense. I mean, what are the?
Oh, no. In New York, you can't get a license even if you can show you're getting it for self-defense.
Okay.
In New York, you've got to show basically you have some extraordinary need for self-defense. So I think the court will. Right. So essentially, if you are in the positive view is if you're in the 5% most threatened people, you have to carry large quantities of money in dangerous parts of town. Then you get it, but 95% don't. That's not an exception to the right, that when 95% of the people can't exercise the right, that's not an exception to the right, that's a negation of the right. The cynical view is if you're in the 5% most well-connected, or in a place where the police department has a relatively pro-gun view, then you get it, and otherwise you don't.
What do you think, I mean, within this case or outside this case, if this case, basically overturns the New York regulation, what do you think is the proper constitutional standard for urban areas in which there are a lot of guns and a lot of gun violence?
Right.
And what is your own view?
Right. Well, so let me just step back and try to answer this question a little indirectly. So in 1985, if you looked at the map of gun regulations in the country, you would find that basically there were 9 states in which you could carry in which any law-abiding adult, more or less, I oversimplify here, could get a license to carry a concealed gun. And 1 state in which you didn't even need a license. That state, turns out, was, and still is, one of them, Vermont. Who knew? Then there were a bunch of states in which you could carry openly, but as a practical matter, very few people did in urban areas. So basically, it was sort of 40-10. In favor of heavy, heavy regulations of public carry. If you look at the map today, it's still 40-10, the other direction. There are 40 states, maybe, depending on how you count them, 40 to 44, in which there is a right to, at least a statutorily recognized right, of any law-abiding adult, cutoff is usually 21, can go and get a license to carry a gun. It costs some money, it may require some training, but you can, although I should say, I'm sorry, the most is unlicensed. In about half of those states, you don't even need a license. They've all gone the way of Vermont. And then there are 6 to 10 states, California is one of them, in which basically it's at the discretion of the sheriff. And it depends on the sheriff you have. Interestingly, if you look at California, you also see something similar. That it varies from county to county in terms of practical decisions by the sheriffs. One of the cities, in LA and San Francisco, virtually impossible to get concealed carry license. Sacramento shall issue. Anybody wants a license, the sheriff's policy is to allow it. So this is the long way of saying that I think if we were in 1985 and the court recognized a right to carry, it would say, well, obviously it's got to be extraordinarily limitable in all of these situations, because, you know, obviously everybody agrees that you can't just have everybody carrying guns in, for example, Manhattan or in LA or in Houston or in Philadelphia or in Chicago. Well, it turns out in 3 of those cities, Chicago, Houston, and Philadelphia, anybody can carry. And people try to figure out, did it increase the amount of violence, decrease? As best we can tell, had almost no real effect.
I'm going to interrupt you just for a moment.
Sure.
Use this to segue over, because it's interesting in constitutional interpretation to take stock of what's going on in the country.
Right.
Changed law, you know, where are the states, how many states are doing this, how many states are doing that, what is public perception, how many people in the country believe this and that. Is that proper ground for constitutional interpretation? And I'd like to turn to the Harvard case.
I love that question.
In this
can
respect.
I can't.
Absolutely.
I
Please.
really want to make sure because
Absolutely.
first principles are public safety and the government's power to regulate firearms. I've already said at the table over dinner, and we worry too much about what goes on at Harvard. Like, I just want to say that. So if we don't get to Harvard, I do not think.
This goes to Eugene's point.
Right. But I'm just saying in general.
You only say that because you're from Yale.
I say this because you're asking a core question and really big picture questions. One of the things that I always try and make sure my students know, and I tell them on the first day of class, and they hear it infinitum, that I want them to leave my class being able to distinguish between legal theory, legal doctrine, and policy preferences. I give them a PowerPoint slide that's got legal theory as an idea about, you know, something important. Checks and balances is a legal theory. Separation of powers. What's the best way to interpret the Constitution? Provisions of the Constitution over which we might disagree. Originalism is a theory. It's an idea. Legal doctrine is what I was describing, a standard of review, and that's the question you're getting at. What is going to be the legal doctrine after New York Rifle Association that a government will have to apply or will be applying, what a court will apply to a gun regulation? Will it be strict scrutiny? Will it be something that's tantamount to intermediate scrutiny? Will it be rational basis review? But then that third box on that slide is red. It's not red because it's forbidden and you can't think about it or have it, but the court tells us repeatedly, justices tell us repeatedly, Justice Barrett was at the Reagan Library a couple of days ago telling us they don't do policy. And lawyers aren't, I tell my students, I am an expert in constitutional law. You are not in public policy school. I am not here to evaluate the empirics of how many guns should be in any given locale. I'm also not a priest. I'm not someone who tells you when life begins. I do recommend you read Roe v. Wade. The court very clearly says that it is not their place as the Supreme Court of the United States to say when life begins. They do not take an issue on that. So the question of who decides public policy has been long decided by the Supreme Court. When you take constitutional law, everybody on the court tells you don't be like the Lochner court, the courts of the 1920s and 30s that did policy, not law. So the court repeatedly and all the time tells us that they lose our trust. They're not acting with principle and integrity if they're making decisions based on their personal policy preferences about whether they think there should be more or less guns in any locale. So that shouldn't technically be in the opinion. And they are going out of their way to convince us they're doing either legal theory or legal doctrine. And so when it comes to the New York Rifle Association case, the issue is whether the government of New York has the power to regulate firearms in a very particular way. And that particular way is through a licensing scheme that does require an individual who wants to carry a firearm to get a license to do so. And what they have to demonstrate is they have to meet a purpose, a special purpose requirement that many of the justices in oral arguments did characterize as somehow denigrating the First Amendment, the Second Amendment right, and they seemed very troubled by it. But as far as let's boil down on what the government power is, it is saying that the way we want to regulate carrying a firearm in the state of New York is that you have to demonstrate to an individual who will have that power to make a decision, which some of the justices were very concerned about, that you have a special need for self-defense outside the home that differs from the general population, that somehow you are different. And what tells us how interested this court is on deciding this question is that the issues of whether it's 95% or 5% or how often you get one of these licenses has yet to be tried. That the court is deciding this on really the legal question without having a sense of how often and how difficult or challenging it is to get this license. From the oral argument, some of the individuals who've gotten these licenses can get this license because they walk to their cars in a dark parking lot at night. I mean, there's not clarity as to how high or low this burden is. But when it comes to the question of what the legal issue is, we do already have DC versus Heller, where the court for the first time, and I would characterize the Second Amendment jurisprudence and the precedent a bit differently. I tell my students that when I went to law school, which is when you went to law school because we weren't too far apart, that it would have been absurd, honestly, and people would have kind of looked at me a little strangely if I said, when are we going to talk about the Second Amendment, Professor? Because when I went to law school, the Second Amendment was like the Third Amendment. It was anachronistic. It was a part of the Constitution that didn't have modern meaning. The Third Amendment says that you can't be asked to quarter soldiers in your home. And why aren't there cases about it? Because it doesn't happen often. The Army doesn't knock on your door and say, hey, can we bunk up in your bed tonight? But if they did, there would be a Third Amendment case. So I wouldn't say that it is demonstrative of the Second Amendment getting no attention, but that's definitely, and Eugene and Professor Volokh, I'll call you both intermittently, is absolutely right that is how the Second Amendment jurisprudence is characterized in the lead opinion in DC versus Heller. But if you were to read the dissenting opinion, it is an opinion that is filled with references to precedent. And it is an opinion that I think is much more analogous to what we're looking for in Dobbs, that the justices in dissent in DC versus Heller were saying, well, US versus Miller might be a little short and wonky. I've assigned it in my classes. Well, it's short and wonky because everybody understood that it was about militia duty, that the words and the text in the first part of the Second Amendment were actually crucial to understanding what the entire provision meant. I'm sharing the stage with someone whose law review article was actually very instrumental and was cited to show the proposition of maybe we could look at those words differently. The whole idea that there's a prefatory clause versus an operative clause to the Second Amendment, I don't think it was there before DC versus Heller. And again, I can't imagine as a scholarly accomplishment, having a law review article that is cited for that proposition. I tell my students that part of DC versus Heller is doing far more work than all the other pieces that look at the words keep and bear, that different in approach. And so what I would say about the difference between the majority opinion in DC versus Heller and the dissenting opinion is that one is an original meaning originalist opinion. And if you look at what the sources of meaning are that original meaning originalists rely on, it is again not what James Madison thought. It is instead dictionaries from the 1700s. It is law review articles and scholars from the 1700s. These are the people who, if given the chance to figure out what the Second Amendment means, and they had a time machine, they would not go to the room where it happened. Thank you, Lin-Manuel, right? Like they would go instead to the library of the past. And what the dissenters do, and I do not think it is an originalist opinion, it is common law constitutionalism. It is first and foremost an opinion that is saying the precedent is US versus Miller. And so then after that they say, but even if precedent does not dictate the outcome of what the Second Amendment means, we would go to the room where it happened. We wouldn't be constrained by the room where it happened, but let's dig into what James Madison thought. And so there is a way to see the difference between those opinions. But writ large, I think the important point is to always think about these questions as how is government power limited or not by the Constitution? And so the two cases we've talked about already show that variation. That if you're going to apply a heightened level of scrutiny, it's going to mean the government has less power to regulate. And so there's going to be local control over what the rules of the road are when you're going to terminate a pregnancy. If Dobbs comes out the way we're talking about, that means there'll be more local control of whether a pregnant person can terminate a pregnancy pre-viability. It will vary from state to state, city to city, locale to locale. What this change for the Second Amendment means, and what New York Rifle Association will further entrench, is that instead of there being local control, Justice Breyer writes a dissenting opinion in DC versus Heller where he tries to make this point, that his argument is that because guns are uniquely dangerous and the government has really a built-in compelling purpose to regulate, that we should leave it at the speed bump rational basis review. That would have been if we'd had the old-fashioned, when I was in law school, interpretation of the Second Amendment. But short of that, since we've now got DC versus Heller, that you would have seen something more tantamount to intermediate scrutiny. Because with strict scrutiny, which is what the plaintiffs in DC versus Heller wanted, I don't know if the court is going to go as far as to actually use the magic words of strict scrutiny. But the higher the hurdle is for the government to regulate firearms, it means that there will be more uniformity across the nation. But I would say what we need to be thinking about is, and this is why it's a class about, this is an issue about government power, where do we want local control? I think there's a very strong policy argument, and again, I'm not a policy person, that's not my area of expertise, but when it comes to when I think the Supreme Court should defer to local authorities, the city council, the state, I think it makes a lot of sense to have a theory of Second Amendment jurisprudence where you have a lower standard of review, because then Vermont can have a different rule. Why is Bernie Sanders not for gun control? Because he lives in a part of the country where people hunt and where they don't have a subway system. So I think there's a similarity across these issues.
This has been a really fascinating.
If I could just
Sure.
briefly respond to this. So I want to just step back of this and just identify a few big picture points. One is that I totally agree with Kimberly. This is a question, as so many constitutional questions are, about local control. And incidentally, state-federal power questions on the structure side are also about that too often. So the view of the conservatives on the court, more or less, is, well, we look at the Constitution, and as we read the Constitution, it says speech, religious practice, right to bear arms, searches and seizures, privilege against self-incrimination, those things are things that the Bill of Rights basically withdraws in considerable measure from government control, both federal and state and local. Whereas other things that are not listed there are, generally speaking, not withdrawn. This is an oversimplification. Interesting questions, what do you say about the Ninth Amendment and such. Some others say, well, no, we should take a more functionalist view. And certain things that are not enumerated make sense to withdraw from local control, such as sexual autonomy or such as reproductive rights. And other things that might be enumerated probably make sense to leave to local control, such as impairment of obligation of contracts or regulation of arms, because that's our understanding of what kind of makes sense for our democratic polity. So that's an important question. Neither side is in favor of leaving everything to local control. Neither side is in favor of withdrawing it. They just have different rules about that. A second point, though, I want to say, and there's also all this stuff about how you interpret militia clause, how you interpret all those things. I'm happy to bracket that. But the second point is very important, I think, that Kimberly mentioned, that is about the role of policy arguments. So remember, strict scrutiny is one thing that came up a lot, intermediate scrutiny. That's a way of saying that a constitutional right can be restricted, at least in certain not very broad ways, if the restriction is narrowly tailored to a compelling government interest or substantially related to an important government interest. That's intermediate scrutiny. There are other formulations as well. So probably if you do have a rule that basically denies the right to most people who want to exercise it, that's not covered by that. That's not even really a regulation anymore. That's a prohibition. But if it is, what kind of licensing schemes are allowed? What the age cutoff might be? What might disqualify you? Some of those things, if they're filtered through strict scrutiny and intermediate scrutiny, all those tests say is there is a public policy dimension. Maybe in determining the scope of the right, you have to think in terms of constitutional theory. But in terms of deciding how to apply strict scrutiny and intermediate scrutiny, they directly call for this policy analysis. So if in any area where the court says there is a right but subject to trumping under those standards, by the way, not all areas. For example, there's no strict scrutiny escape hatch from the jury trial right, or from the public trial clause. Although actually, there is actually in the public trial clause, but not for the, say, the jury trial right. But in most areas, there is an escape hatch, and that's where policy comes into constitutional analysis. And both liberal and conservative justices have more or less made their peace with it.
So one of the most important policies for tonight is that we have to go to Q&A. We've left education behind because we had really interesting issues on freedom of religion and the role of race in admissions, if that's how you view the Harvard case. I'm not so sure.
Well, could I just say
Please.
one thing that I would say that would connect to the Harvard case? It's about the Equal Protection Clause. To make my point about the court and its approach to what original meaning originalism means and why I say it's very judge empowering. What Eugene said is right, that the kind of the rhetoric around why we're going to have a certain set of enumerated rights that could never be subject to rational basis review and the majority should never have a weigh in on is supposedly because they're listed in the Constitution. But do read the Second Amendment. It never says there's a right to bear arms for purposes of self-defense in the home and for hunting. But that's literally the holding. And so it is not just simply the text. What the lead opinion in DC versus Heller does is it does a lot more than reads just the words. And there is a word liberty in the Due Process Clause that could be interpreted very broadly to protect, again, a right that has no longer been, it hasn't been subject to strict scrutiny for quite some time. So where I think the policy and rhetorical and ideological arguments come in is when we say, well, this factual context matters, and this is somehow a right that, because there are, I think the other point is there are no absolute rights. There aren't absolute rights. Justice Scalia says that in DC versus Heller. So there's always going to be a question of what the standard of review should be. But when it comes to original meaning originalism and this interest in engaging in the history and tradition and the text around a provision, we don't see that when it comes to race-based affirmative action cases. So we're not going to see that. I do not think we're going to see any of our original meaning originalist justices, no matter how they rule on SFFA versus Harvard. We're not going to see them go back to the Reconstruction Congress and think about what the radical Republicans who are interested in the citizenship rights of African Americans have to say about whether someone didn't get into Harvard or not. So I do think there's a lot of connections to all of these things, and so I really appreciate this opportunity to engage, and I love that I've finally gotten the answer to my question from that I've always wondered whether Eugene was an originalist or not, so now I know.
All right, Maya, let's move to questions. You can see the complexity of these multiple dimensions and looking at cases from wildly different areas, but in comparison to one another. And you can see the competing ideas that filter through the deliberation and adjudication of these cases in real time through these amazing experts. So let's move on to questions. Maya.
Awesome. So yeah, we'll move on to the Q&A portion of the evening. If you have a question, we ask that you line up behind either of these two microphones on the ends. When you get up to the mic, just introduce yourself, name, major, year. Thank you.
Hi, I met you both in the reception earlier. I'm Desmond. I'm a junior here at CMC studying government. I wanted to ask about one of the briefs filed in New York State Rifle and Pistol Association, which was about the potential for New York's laws to systematically disenfranchise black and low-income applicants for concealed carry permits. I work at the Rose Institute here on campus, and I studied a very similar phenomenon in California's permitting system, which, as Professor Volokh mentioned, is county by county or sheriff by sheriff, and found very similar results using census data that it systematically discriminates against black and low-income, as well as foreign-born or Hispanic applicants in California based on where they live in certain counties that are more restrictive for concealed carry permits. Is that just a policy concern, or is there some constitutional merit to holding something to strict scrutiny because there might even be perhaps an equal protection concern there, or even if not, a very serious concern about entire demographics getting left out of their right to bear arms?
I'd say that it is not, it is a policy concern, and to me, I find it absolutely fascinating that even in DC versus Heller itself, that arguments that are supposed to be about what the Second Amendment means are being buttressed by arguments about whether African Americans are being discriminated against in this realm. frankly, in most everything in our society, we would be able to say that. We could certainly say it about access to reproductive rights, and we could say it about Dobbs. We could probably say it about private or public schools. I mean, it is, to me, that is more resonant in the court of public opinion as far as a doctrinal question, but there may very well be difference of agreement.
It's also disparate impact, right? And so,
well, there is no
but-
disparate impact claim
Right.
under the Equal
I know
Protection
there's
Clause.
no
That's
claim.
absolutely right.
So
But could there be a claim?
Well,
That
but
I
that
agree
would
with
be
you.
a completely different lawsuit. It would have to come after the court has actually answered the question of whether the Second Amendment protects a right to bear arms that is so broad that a government cannot have the licensing scheme that's at issue. So I would say, if it were on my exam, it would be a student writing about an issue that really doesn't have a role. And so I'd say it's in the red zone. And I would say, because I've told you on my exam, I want issue, rule, analysis, conclusion. But it could very well be that that'll be the brief that gets cited by the Supreme Court, because maybe that's what they want to be in the paper on the morning we hear about this. They don't want it to be the news that came out of New York yesterday, right? Like there are some very serious things at issue when we're saying the government can't regulate firearms. I mean, people are dying. And so I think some members of the court would much rather us think that they are interpreting the Second Amendment as somehow an avenue to racial justice. But if you know the rest of the court's doctrine and the way they interpret the Equal Protection Clause, that really falls to me on deaf ears.
So I have a different view of the subject, but in part because of the way that things are often done. I know the one area I know best is the First Amendment. So it's an interesting analogy. What we're talking about here is discretionary licensing schemes. And it is quite right that a discretionary licensing scheme where no constitutional right is in play is something that is constitutionally permissible, subject just to the rational basis test, all sorts of rational reasons to have discretionary licensing schemes. Classic example, not exactly licensing, but analogy, discretionary hiring by the government, right? There's nothing unconstitutional about that. And then if you think that there is discrimination in that, if you can prove it, then you can get an equal protection claim. But you've got to actually prove intentional discrimination, and that's very hard to do. But when a constitutional right is in play, and the government's response is, well, we need to regulate this right, not prohibit it, but regulate it. And the way we regulate it is through a licensing scheme. Then I think the court's reaction may very well be, wait a minute, there is a constitutional right in play. We're willing to let you regulate it. I think almost none, or maybe none of the justices take the view that the right to keep and bear arms cannot be regulated at all. They'd say we'd be willing to regulate it, but we're really suspicious of discretionary licensing schemes because we're afraid what's going to happen is people who are on the ins with the sheriff win and on the outs lose. And that's probably going to be connected to race, certainly going to be connected to social status and economic status and the like. So the one clear analogy is the free speech clause. Is it permissible to have a licensing scheme for demonstrations? Yes, the court has held from the dawn of the free speech era, in part because otherwise you have two parades that are trying to be on the street at the same time. Neither one of them can be really effective, and you're probably going to get people punching each other. But early on, the court said, but it can't be a discretionary licensing scheme. So you could have rules that are relatively objective, but the more it just looks like, I think you really need it? So no, that's generally not enough in the free speech area. Generally, I think the court would say that's not enough in the Second Amendment area. I'll give you an example, by the way. That's true even when it comes, at least in some measure, to government property. So the court a few years ago said it's unconstitutional to limit political T-shirts and signs at polling places. Now it's clear that all sorts of things can be limited at polling places, but the way that political had been defined by Minnesota was totally pell-mell. Nobody could predict it. Like it got to the point where quoting the First Amendment was not political, but the Second Amendment was political. So whenever the court thinks that there is A, a constitutional right involved, and B, a scheme that has so much discretion that the government gets to decide who wins and who loses, that's something that, yes, in many areas the court quite frowns on.
Free speech may be a little different in this respect than guns, but
Just
get
a
on
little.
to let's
Just a little.
let's have another
Thank you.
another question before we conclude. Thank you.
Hi, my name is Sobe Chukwuyiwaje. I am a senior at CMC, and I'm a public policy major. So I thought it was really interesting as you guys kind of discussed the interplay of law and policy. And I have two questions, or two-part question, both kind of around manipulating laws and the role that people have as whether they're legislators or as in the judge. So first is, you, Professor West-Faulcon, you mentioned how in Casey, like there are certain legislatures that are intentionally creating laws so that it can go up to the Supreme Court and hopefully get overturned. And I was wondering, one, is it always that obvious, or is it a bit cynical to kind of assume that, or is it something that's clearly stated as like we are intentionally trying to restrict access so that this law can get overturned throughout the United States? And then kind of on the inverse side of it, you also mentioned how the court should not be making decisions based off of their personal public policy opinions, which I'm wondering what other reason, or how do you approach the law as a judge without bringing in your personal public policy opinions? Do you have the obligation to do so to some extent because you're being elected in some part, or being nominated and selected in some part because of your opinions previously?
Excellent question, and I think we could be critical theorists, and I don't know if Eugene would appreciate me saying that, but I think that the idea
sure,
of legal
please do.
realism is what you already opened us to by saying that they're humans, and can any human control their unconscious, subconscious tendency to analyze a question and reach a conclusion that lines up with their personal beliefs and policy preferences? We don't know that they can, but what judges are supposed to do, and what we teach our students that constitutional law expects to be the gold standard for their conscious behavior, is that they not behave as if they have a different job. And that there's a diagram I always use with my students, and at the top of it, it's government power, and then there are two entities that have power. It's the federal government and the state government. And again, Schoolhouse Rock, there are three branches. And if you want to be the branch that decides how stringent our gun regulations will or won't be, based on whether you think we need more or fewer guns to stay alive, you should run for Congress. That's the theory of it. Then run for Senate, run for the US House, run to be the governor or the president. And what every single justice up to this point, now there are many things they're changing, and I don't have crystal balls for most, but right now, all of them would say, we are not a legislature. We don't want to be a super legislature. And that's where this terminology of judicial philosophy fits in. I think it's really another version of saying maybe your theory of constitutional interpretation, how much you think you should step in and overturn prior precedent, how much you should step in and review the actions of the elected branches of government. Eugene and I have been on the exact same page on that. I think the point that I am just trying to make is that the court's integrity, and they understand it, is tied up with convincing us and us believing that because they are not elected, and you well know that we don't have a significant check on them. Like, we don't impeach Supreme Court justices because they have a bad judicial philosophy or they do their jobs poorly. So they pretty much have their jobs for life. And so the only way we sleep well at night is believing that they, at least in their conscious minds, try to constrain themselves and do what I teach my students I want them to do, is at least in your conscious mind, distinguish between a legal theory, which would be, even if you're an original meaning originalist, this is the way I always do it. What is unprincipled if you do it one way when it is one provision of the Constitution, and you do it another way when there's another provision of the Constitution. And I think it's virtually impossible, if you're not reading a whole bunch of Supreme Court cases, to then evaluate who's being principled or not. So when you listen to one oral argument, everybody sounds smart, everybody sounds genuine, everybody sounds sincere. It is really looking at the consistency of their application of that judicial philosophy. And what can sadden you, and where we legal scholars come in, is we spend our lives reading and comparing, and then we kind of come back to the world and go, you know, they tell you they have this judicial philosophy, but they use it kind of, and Justice Kavanaugh likes to say it, you know, you shouldn't do this like you're looking out at the crowd and picking and choosing your friends. But the reality is, I could critique Justice Kavanaugh's own opinions for picking and choosing his friends. So that's what it is. It's, are they consistent over time? And again, if you have policy preferences and you want to see them, whether it's economic policy preferences, you think we should have more or less regulation, the big picture point is, then run for office, because if we don't like your economic policy, you're against the minimum wage, you're for the minimum wage, we can vote you out of office. The judges have to convince us that they are doing law, not policy, for us to sleep soundly. And so the day we don't trust the court, and that's what happened with the Lochner court, is people didn't trust them because they were just showing time and time again, they just thought they knew more than the president and the Congress. So that's kind of a reiteration of what I'm getting at. I'm not saying it's easy, but that's what the court tells us they're trying to do.
This principle,
yeah.
I know we have to conclude, but this principle of self-restraint and legitimacy is important for all of us and in all professional pursuits. It's particularly important in terms of the role of the court and how we perceive that self-restraint.
Right.
Eugene,
Well, so I think there's a very, very great deal to what Kimberly says. I agree with probably almost all of it. Justice Thomas would agree to probably pretty much all of it. And I think he's a pretty fair bet because of what he said before, for saying he would reverse Roe v. Wade and Planned Parenthood v. Casey for the very same reasons. He'd say, abortion, you know, it's an important subject. My views on the subject don't matter. What matters is what the legislature says, because that is something that is left to the legislature. There's nothing in the Constitution that says that. Sure, you point me to liberty, but first of all, liberty cannot be denied without due process of law. An enacted statute that prohibits some kind of conduct sounds like the quintessence, at least he would say, of due process of law. And to the extent you say, well, no, liberty includes a right to reproductive choice, because nothing in the Constitution says that, and nothing in kind of long-standing history and tradition says that, that means you're just making it up based on your own ideology about liberty. Now, you might say, well, what about precedent? And he's actually told us his answer to that. He says, Article 6 of the Constitution says that judicial officers shall be bound to support this Constitution, bound by oath. He says, I took an oath to support the Constitution. I did not take an oath to support precedent. Now, to be sure, I care what others have said, because this is something like I respect them, and I think there's a lot of wisdom in what people have said. I'd be a fool to ignore it. And as a practical matter of judicial administration, you can't just have everything be constantly up for grabs. You can't run a system that way. But if I think that my oath to the Constitution really requires me to read a provision one way, and precedent requires me another way, I'm going to follow my oath. That's what he would say. Now, maybe he's wrong on these things. Maybe, in fact, justices should look to their belief systems and read liberty expansively. Or maybe once some justices have read liberty expansively in a precedent, future justices shouldn't be free to reverse that. But I think it's important, whatever your views are of abortion might be, that what Kimberly said is in a sense the classic argument for not having decided Roe v. Wade the way they did. So in other words, for the dissent in Roe v. Wade, and add to that this oath in Article 6, oath to support the Constitution. That's the argument for reversing it. Maybe it's not right in this situation. Maybe this is an area where we want the justices to provide these extra protections and read liberty based on their ideas, which we may think are the right ideas. But that's what's at stake in Dobbs, I think.
You can all see a lot at stake. We failed you in not self-restraining us to the 8 p.m. deadline, but want to thank our tremendous guests tonight, Kimberly and Eugene, and thank you all for joining us.
Thank you for having us.